Hello, and thank you for joining us today for Lessons from Touching a Hot Stove Legal Edition. My name is Julie Weller, and I am an attorney in the automation and robotics practice of Faegre Baker Daniels, an international law firm. I am pleased to introduce my colleagues, Mark Voigtmann and Brian Clifford, who have decades of experience in automation and robotics law, including representing many CSIA members as part of the CSIA Legal Plan. We really enjoy the Lessons from Touching a Hot Stove session at the CSIA Executive Conference, which got us thinking. Mark and Brian have plenty of their own hot stove stories to tell. The name of this session comes from a quote by Mark Twain. "The cat, having sat upon a hot stove lid, will not sit upon a hot stove lid again, but he won't sit upon a cold stove lid either." Today, Mark and Brian will share some hot stove stories with you and what could have been done to avoid them, with the hope that your business does not experience the same burns. I will now turn it over to Mark and Brian to get us started.
So this is Brian Clifford. I think, unfortunately, Mark Voigtmann is muted for just 1 second, so bear with us for just a minute. I think he needs to unmute himself.
Oh, I'm sorry. Can you hear me now?
Yeah, thank you, Mark.
Okay, well, thanks to Julie Weller for that. I think we should start off, Brian, with talking about a common conundrum that automation companies face, something I would call the conundrum of pre-existing equipment.
Well, I like that word conundrum. I need to use that a little bit more, I think.
Well, you may not know this, but it takes a law degree to use that word.
Totally not true. So when you were thinking about pre-existing equipment, Mark, are you thinking about a particular project?
I'm actually thinking about two.
Okay, two different projects, each one involving pre-existing equipment?
Yes, and let me give you a little background here. You know, one of the things that you and I talk about a lot is how automation and robotics projects are similar to sticks and bricks construction projects in some of the ways in which they are different.
Yep, we do.
And one of the ways that they are different is that in automation projects, there is some level of integration. Are you with me so far?
I am, but let me challenge you on that, for just a moment. I mean, there's some level of integration in all construction projects, is there not?
Oh, yeah, I suppose.
Well, like, the drywall installer has to integrate his work with the company putting in the heating and air conditioning plenums, for instance.
I agree. I'm with you.
Yeah, well, they have to coordinate their schedules, right?
Yes.
And the drywaller can't put up the drywall where an air plenum needs to go, right?
Certainly.
Well, so there's really integration in all types of projects, true?
True, but I'm talking about a particular type of integration here, integration with pre-existing electronic equipment. And I know you are probably going to say that there is pre-existing equipment even on traditional construction projects, but I think you will agree that on automation and robotics projects, there are almost always tie-ins to existing electronics that can create special types of issues different from traditional construction.
Yeah, okay, I'm with you. I can sign on to that.
So I'm going to give you two examples. These are hot stove problems that have led to getting at least a little seared, but I would say thanks to us, not very badly burned.
All right. So what happened in the first? Can we give it a name?
I believe we can. Let's call this first problem the case of Houston, we have liftoff.
The case of Houston, we have liftoff. Okay, creative title.
And it actually takes place not far from Houston, as it turns out.
Oh, okay.
So let's get into it. Let's just say that you are the trusted employee of a control system integrator and you are working in a natural gas facility.
All right, so we're talking about an individual person here.
Well, he's one of the many workers for the integrator, but we're focusing on just this one worker for now.
All right,
okay?
So why is the integrator in the facility?
There are several reasons why the integrator is in the facility. One of the main ones is that the integrator is helping the gas company migrate to a new SCADA system.
Oh, okay. All right.
And of course, this is a big facility with a lot of different lines. a lot of different processes going on.
All right, and the Integrators project is just a small part of it?
Well, it's a significant part of it, but let's just say that there are systems in this facility that are not touched by anything the integrator is doing.
Okay, so why are we focusing on this particular guy?
Because this particular guy is working in the control room for the gas facility. You've seen these places. A clean environment, lots of panels. This is the central place where all of the systems in this facility are controlled and monitored, and our guy is in there, and he is working on a particular panel.
Okay, that sounds familiar.
Something a little freakish happens. He's moving from one place to the other within an area of this control room, and a piece of equipment he is holding just happens to hook onto a breaker switch in a nearby cabinet.
This does not sound like something that's going to have a happy ending.
It's certainly not something that you want to have happen.
No.
But accidents happen.
Yes, they do.
And when this piece of equipment hooks onto this breaker, it flips the breaker.
And so that means something was turned off.
Something was turned off. It does.
What was turned off exactly?
The entire facility.
The entire facility?
The entire facility.
That is not a small event.
This is not a small event because this is a very big facility, but it lasts for only a short time. That's the good side.
Well, why? Because they, flipped the switch back on?
Exactly. They were able, within a relatively short period of time, to discover the problem and flick the breaker switch back on.
All right, so no harm, no foul. Is that what we're saying?
Not exactly.
Well, why is that?
So, as you can imagine, natural gas facilities have a particular way of dealing with the systems when the facility is shut down. And what happens is the natural gas is directed to something called a flare system. And the flare system is you've seen these. It's like fire coming out of the top of smokestacks. They're burning off. They burn off the natural gas, okay? So in this case, the natural gas, because the facility was shut off, went to the flare system. And somewhat unexpectedly, the flare system blew up. And as a result of blowing up, it shoots the tip of the flare, which is the cone-shaped thing at the very end of the stack that the fire comes out of. It shoots it 1,000 feet into the air. And it lands about a mile away.
A mile away? Wow.
Not only that, but as you can imagine, when the natural gas leaves the processes, the pumps no longer have natural gas running through them. Now, one of those pumps, a very important pump, continued to run without any natural gas in it and burned up. So it did not really matter whether they could flip the breaker switch back on because this was a very key process pump and there was no pump to pump the natural gas. So basically, effectively, the plant was shut down for a few days before they could replace the pump. So a lot of damage just from a little mistake.
Wow. So what happened next?
Well, as you might expect, a significant claim was asserted against the integrator. And here is what the gas facility is saying. Your guy was negligent. He tripped the breaker in our facility. The facility shut down and sent gas to the flare system. That caused our flare system to blow up and the flare tip to attain escape velocity. Now, not escaping the Earth's atmosphere, obviously, but escaping the area of the factory. And it also caused our process pump to burn up when it ran on empty for too long. And that caused our facility to be offline for 2 days. And you owe us for all of our lost production during that time.
Wow. Well, that does not sound good.
No, it does not. But there's a few things we can say here if we are the lawyers defending the integrator, right?
Yeah, I can think of a few.
So tell me one if you can.
All right. Well, how about that? This poor integrator. How is he supposed to know that all this mayhem would result if you turned off the plant?
Not exactly a foreseeable set of circumstances, is it? But I mean, let's
Right.
talk about that, right? So flare systems, they have only one function, right? They're supposed
Right.
to burn off the natural gas when it's redirected when the plant shuts down. So they're not supposed to blow up. They're not supposed to launch.
Right.
Process pumps. So there was something wrong there, right? Process pumps are supposed to shut off automatically whenever the gas is diverted away. They're not supposed to run forever. In fact, there's an automatic switch that in this case was disabled by somebody, not the integrator.
Mm-hmm.
So we have a pre-existing equipment problem here. The integrator was not hired to update all of this pre-existing equipment. It was migrating a SCADA system from one platform to another and some related work to that. So the bottom line is that none of that damage would have happened if the owner of the gas facility had properly maintained its own equipment.
All right, but look, I mean, the integrator's still in trouble, right? Because I mean, no matter what you say, ultimately it was the integrator that caused this whole chain of events to happen. I mean, you really can't deny that this guy in the control room started the chain of events. I mean, if not for him, none of this would have happened, right?
True. He was in person. He was in fact the person that caused everything to happen. But, and I think you understand this concept, he was not what the law would say was the cause of this. He was not the legal cause.
All right, yeah, I'm familiar with the concept. I mean, lawyers call this proximate cause.
We learned that in law school. I mean, one can always point to an earlier event that causes everything else to happen.
Right. So we're able to get the integrator out of this?
Yes, or perhaps put better, we were able to get the integrator off the hook for liability. We were not able to get the integrator out of the hassle and expense of dealing with the claim.
So are there lessons to be learned from this?
There are. And here they are. One lesson is really an observation. Many, perhaps most contracts signed by automation companies do not really address the situation of pre-existing equipment, and they need to do so.
All right, well, how would you recommend going about that?
Well, at the minimum, the top line there, acknowledge no responsibility for pre-existing conditions of equipment that is not supplied by you in your contract. Put a line about that in the contract.
All right, well, how about going actually one better? I mean, create an affirmative obligation on the owner to coordinate anything you are doing with its pre-existing equipment.
I think you must be reading off the screen, Brian, because that's the second point there. And that's great. But the best protection and what, as you know, you and I typically recommend is to get an indemnity agreement from the owner for anything that goes wrong with its equipment, anything.
Right. Well, and for our listeners, an indemnity agreement's, just a paragraph that can include a lot of different stuff bundled up with it. But one of the important things is the agreement by the owner to hire a lawyer to defend you as the integrator in the event you get sued by someone because of the owner's pre-existing equipment.
Exactly. So in the case of Houston, we have a liftoff. It was a fortunate situation. There was a lot of damage, but nobody was injured.
Why do I have a feeling you're going to tell me about the second case?
You saw where I was going. The second case is similar, but this time it does involve somebody getting injured. And let's call this one the case of the on-off switch.
All right, the case of the on-off switch. All right, it sounds familiar to the first case.
It is a little bit. So this time we find ourselves in a factory with something called a laminator. It's a big machine with heavy rolls that press together materials that are combined with each other.
It sounds potentially dangerous.
It can be, and it was. So here briefly is the story. So prior to the integrator being involved, this machine was just a manual operation. There were a number of steps involved in raising and lowering these big rolls. And once those manual things were done, the rolls came down. And the integrator was brought in to automate those steps so that the process would be smoother. So the integrator was basically told, replace this hardwired on-off setup to a PLC-driven setup. In other words, the integrator was more or less installing a new type of on-off switch, which is why I call this the case of the on-off switch. Now, there was a design philosophy to the way the laminator worked, and there was some attention to safety. There were some e-stop or electronic stop switches in different places on the machine, but the integrator never really was involved in any of that stuff. In fact, they weren't really in the area of the laminator at all. They were just doing the on-off switch in essence, and the integrator was never asked to question the design philosophy of this laminator. And get this, are you ready?
I'm ready.
Someone was injured, of course, which is why we're talking about this, but the engineer working for the integrator had never actually seen the machine being used in the way that it was used at the time the person got injured.
Interesting. I would think that's something that would help the integrator.
You'd think so, right? Because the integrator was not hired to second guess the way the pre-existing equipment operated, including its safety procedures. That was way beyond what it had been hired to do.
So how did it happen that someone was injured?
Well, we probably are not going to need to get into the details, but it's the way people get injured on machines like this. A worker got his hands caught in the rollers, and it was a bad injury. Okay,
so then what happened after this injury?
So believe it or not, the integrator gets a call from the factory. The factory says, we'd like you to take a look at the safety design of this machine. So the integrator sends somebody who takes a look at the setup and says, you guys really need to have a safety assessment done on this thing before we can even touch this. Now, after you do that, we'll then design something for you that makes it safer.
Okay, so the factory then, it does its own safety assessment.
It does. The factory, the owner, performs a safety assessment. It sends the assessment to the integrator. The integrator comes up with a set of improvements that can be made to the setup. And then crickets. The factory sits around for a few months. Nothing happens.
Wait, so are you saying the factory does not then hire the integrator to put in the improvements?
Correct. Nothing is done.
Oh, jeez. All right, well, so then what happens?
Well, you probably saw this coming, right? A second person is injured.
Same machine?
Same machine, same problem. A worker's hands get caught in the rollers.
Jeez, this is not good.
This is not good. There was a lawsuit, of course. In fact, there were two lawsuits. One from the worker who was injured after the on-off switch was put in, and a separate lawsuit from the second worker who was injured after the integrator made the safety improvement recommendations that were sat on and not implemented by the owner.
Wait, so both of these injured workers sued the integrator?
Yeah, the integrator. Yes, indeed.
Why didn't the injured workers just go after the factory or the company they were working for?
Well, they did, but, and you know the answer to this, and that's why you asked the question, Brian, but the workers' compensation system in this country strictly limits the exposure of companies to their workers.
Well, hence you want to find someone to blame.
Sorry to say, but that's what lawyers do.
Okay, so I'm curious about the first worker who was injured. I mean, that was the one where the integrator had only been hired to install kind of a glorified on-off switch, right?
Correct.
All right, and that the integrator had not been hired to look at the safety of the machine, right?
You are correct again.
All right, so what was the personal injury lawyer's argument in that lawsuit?
Well, his argument was as follows. Mr. Integrator, when you walked into this factory, when you touched this laminator machine, you had an obligation to prevent injury. You should have investigated how it worked. You should have pointed out the safety problems. You should have recommended changes. You should have implemented changes.
But the integrator wasn't paid to do any of those things.
Right. The integrator basically substituted a manual way of starting up the machine with a more automatic way of of starting up the machine, right?
Well, did that change render the machine any less safe?
No,
I mean, did making that change have anything to do with the injury?
not really.
Jeez. So what happened?
Well, the cases were both settled, and ultimately, with our help, the integrator did just fine. But the settlements did not come until after 2 lawsuits and a lot of legal expense.
I understand. I mean, even though the integrator arguably had a winning position, that doesn't mean it's not going to get dragged into something.
Exactly.
Well, which I guess brings us again to, what are the lessons learned here?
It does.
So what can we learn from this case of the on-off switch?
We can learn a few things. Number one, whenever those of you in the integration business do work for a customer, the systems you design potentially affect the people that work there. And that's not as much a problem for your customer. Your customer is protected from the personal injury claims of its workers by workers' comp laws. You are not protected. Number two, just because a customer does not do a safety assessment of its working environment does not mean that you cannot at least do a rough one. And your safety assessment is kind of a black or white thing. Do you want to be involved in this project or not? And if there is something about the project you don't like, even if you can't put your finger on it, walk away. And finally, number three, we've said this before on the prior launch example, indemnity. Same thing we were talking about, the contract between the customer and the integrator can address the subject of pre-existing equipment very specifically. If you're not being hired to address safety, the contract should say that, and it should say that the customer takes 100% responsibility for present safety conditions, and it will defend and indemnify you, which means it'll pay for a lawyer to defend you and pay any judgment if you are sued. So even though the workers' comp shield protects the customer, if the employees sue you, the injured employees, you can push it off on the customer, which means that the customer does not have a workers' shield comp against its contract with you.
Oh, interesting. Okay. So I do have a question, though. I mean, there was the first worker injured after the on-off switch was put in, right? And that's where the integrator had not been hired to do anything about safety. Okay. So, but then there was a second worker that was injured after the integrator had made its safety recommendations, but before they were implemented. Do I kind of have that right?
Yes, you do. You do.
Okay. So which of the 2 injured workers had the stronger case?
Well, the first one did, because with the first worker, it was argued that the integrator should have raised the safety issues, but did not. So that makes its case stronger. For the second worker, you may recall at that point, the integrator had been hired to look at the safety issues and had actually made some recommendations, but they were not followed. The company hadn't got around to it yet. So it was really hard in the second case to point to anything wrong that the integrator had done.
All right. That's a little counterintuitive that the first one had the stronger case, but I guess that makes sense when you think about it that way. All right. So Are you ready to shift gears here a little bit?
Sure. Now, do you want to take a turn and talk about a hot stove situation in which you have been involved?
I do. And Mark, we see a lot of integration contracts, don't we?
Perhaps hundreds per year between us and the rest of the automation and robotics team here at Faegre.
Yeah. So how often do those agreements include some sort of a provision about scheduling?
I would say most. Turns out that many customers like to know when their projects are going to complete it, Brian.
I mean, imagine that, right? And how would you characterize those provisions?
Okay, so in my experience, I'd say they typically say something like, no matter what, the work has to be done by X date, right?
Well, yeah, and that date is always based on just a complete understanding of what it takes for the integrator to create a state-of-the-art customized solution for the customer that's proposing those contract terms, right?
Not really.
Exactly. Oh, and somewhere in those contracts, do you sometimes see the phrase "time is of the essence"?
Yes, We often do, and maybe you should explain what that term means for the non-lawyers.
Yeah, well, basically it means, look, there's a schedule for performance and we're serious about it. It's a shorthand way of the parties agreeing that a failure to comply with the performance or delivery schedule, no matter how slight the delay, can be treated as a material breach of the contract. That kind of term also entitles the non-breaching party to terminate the agreement and then pursue whatever rights it has in the event of default by the party that's delayed in performance.
So bottom line, it's mutual too, but it's bottom line, it's a big deal. It makes time a big deal.
Yeah, I mean, it really allows a lot of rights to be triggered on even really slight delays in the performance. And you're right that a term like that usually applies to both parties. It's mutual. But frequently the customer's only defined performance deadline is for the payment of the contract price. So despite being mutual on its face, such a term typically impacts the automation vendor much more than the end user.
Well, let me push back on that if I might. I mean, the end user does more than just cut checks, right?
Well, I said defined performance deadlines, those explicit in the contracts, but what were you thinking about?
Well, I mean, doesn't the facility owner always need to provide some important information to the automation contractors about the facility, about the process, and about the equipment that's related to the integrator solution?
Yes. However, often those requirements aren't detailed in the contract.
Well, that part's true. I mean, many contracts have pages upon pages of obligations for the integrator, but they say very little, if anything, about the end user's role in the project, and that's a problem.
Yeah, that's been my experience as well. I mean, best practices would indicate that a schedule, including key milestones for each party, should be included as a part of the agreement.
So what kind of milestones are you talking about?
Well, in addition to any milestone payments, which is pretty common, I like to see the parties establish their expectations for preliminary design of the solution, the end user sign off on that path forward, a finalized design submission, prior to any fabrication, for example.
You are living in a dream world. You are living in a dream world.
I know. But look, it's like if they sign off with that, then you can go forward and you deliver the equipment, and after completion of kind of the initial phase of work, the schedule could have a period for time for the end user and the integrator to work together on startup and troubleshooting.
Okay, so this happens in every contract. Is that what you're trying to
say? Not exactly. And that leads us to our next case study. And let's call this one the case of the bad taste of blown deadlines.
The case of the bad taste of blown deadlines. Bad taste?
Well, this project involved a new food processing facility in the northeast portion of the United States.
Okay, so bad taste in food processing. That usually is not the way you want that to go.
Indeed.
So what more can you tell us about the actual project, very quickly?
Well, to start, the end user was a joint venture between a U.S.-based company and a European Union-based company.
Joint venture, that already makes me nervous.
Exactly. Two cooks in the same kitchen is not always a recipe for success.
Again, with the food recipe, the food reference, cooks, kitchen recipe.
Right. Well, look, I negotiate contracts all day. I mean, I never claimed to be a stand-up comedian.
No one in this webinar is going to be confused about your job, Brian. What else can you say about the project? Let's get into it.
Yeah, well, the joint venture retained a U.S.-based design firm and automation contractor, kind of a joint entity there, to build the guts of the new facility. I mean, the shell of the building was completed by a separate traditional contractor, though.
So, but everything inside the walls was the responsibility of the integrator? Is that what you're saying?
No, well, that would just be too easy, Mark. I mean, the integrator's contract was for approximately $50 million in design services.
Big contract. Yeah.
Big contract, yeah. Design, equipment purchase orders, and installation. That included all of the controls and plant automation. But that $50 million included agreed upon change orders representing about a 20% cost increase.
Oh, 20%. Wow. How did that happen?
Well, the contract was a purchase order with terms and conditions attached, which was then appended with numerous clarifications and exclusions. And those documents all filed a lengthy request for proposals that the joint venture had bid out to a few different automation contractors, and that RFP had its own terms and conditions.
Okay, so there wasn't like a single true automation contract here. We had a lot of different stuff going on.
Right, it's just a collection of just various documents. I mean, there were numerous inconsistencies and really some straight-up conflicts between the documents, and none of them were customized for use in a complex automation project.
And unfortunately, that is not an unusual situation. Would you agree?
No, not at all. I mean, we see it all the time, as you know, Mark. And of course, no one really looked at the contract until there were problems.
Okay, so anything else we should know before we talk about the problems?
Well, there's one more important thing. The joint venture decided to have certain portions of the packaging and shipping components of the process delivered through a separate vendor that was retained directly by the facility owner.
So those parts of the facility were not within the integrator's scope of work?
Correct.
So that's good, right? I mean, other than the fact the integrator didn't get to include its overhead and profit for managing that vendor as a subcontractor, it at least isn't responsible for the packaging and shipping portions of the facility then, right?
Well, contractually that was true, but in practice, well, this is a hot stove for discussion.
Right. So what got burned?
All right, so we got involved near the end of the project, right after the deadline for completion of the facility and startup production was missed.
That does not sound good.
No, acceptance testing had been delayed 4 different times over a 5-month period, and under the contract terms, there were 20 criteria that had to be met for acceptable completions. These were referred to as the key performance indicators.
Okay, KPIs, we see those in many contracts.
Yeah, and they can be helpful in defining the parameters of successful completion of the project. But in this case, after the second round of commissioning, only 3 of those 20 criteria had been met.
3 of 20 after the second attempt of commissioning?
Yeah, exactly. I mean, the parties had disputes all over the facility. I mean, from the cleaning system to raw material unloading, even the noise levels inside the plant.
So that's when we get involved, right?
Right. I mean, the owner had been demanding 100% successful tests, but it was offering a waiver of some pretty significant liquidated damages for delay if the plant was properly running by a new deadline. And meanwhile, the automation vendor wanted full payment and didn't believe that any of the performance shortfalls or the delays were caused by its improper acts.
So, but if this integrator basically had the whole facility, it had turnkey contract for all of its portions of the facility, how could it claim it was not responsible with so much stuff going wrong?
Well, it claimed that all of the issues were caused by the joint venture's failure to coordinate the work of the separate equipment vendors, including the integration of their controls into the automation vendor's plant control system. And it also claimed that modifications to the food production process, the actual guts of it, that was modified during performance of the contract. And among other things, those caused the delays and at least some of the performance issues.
So this sounds really complicated. So what you're saying, they're basically pointing the finger at each other, right?
Yeah, I'm not sure which finger they were using when they were doing so.
Well, I think this is a family-friendly webinar, Brian, so let's move on from that.
All right, so fair enough. In addition to asserting that none of the problems or delays were its fault, the automation contractor also had a pending change order outstanding that the owner was disputing.
For how much?
$4 million.
Wow, what for?
Well, most of it was for extra work, including the commissioning service that said wouldn't have been needed but for the lack of performance and coordination related to the owner's separate packaging and receiving vendors.
So there's a facility that's not completed on time, wasn't operating correctly, and both parties were asserting claims for millions of dollars against each other. I would say at least one person here had their hand on a very hot stove. So what happened next?
Well, in this matter, we represented the joint venture owner. So
wait, Brian.
Yeah.
You represented the end user?
Yeah. We like to be
extremely disloyal to the CSIA. What are you talking about here?
Well, we like to be, the right people to call for any automation, robotic, and integration.
Okay. Keep going. But I'm not happy.
Yeah. The immediate question basically was whether or not to terminate the automation vendor for default and then basically bring somebody else in to get the facility up and running to these KPIs as quickly as possible. So you and I quickly went to the site. As you know, we met with the owner's key decision makers. We walked the entire facility. We then reviewed all the relevant contract documents and really the emails back and forth between the parties that really told the story. And then we presented a recommendation report.
Right. A true rapid response team, I would say.
And like many disputes, that temperature on this hot stove was turned down by a couple of 100 degrees, but not without some expense and some ruined relationships.
So how was a bigger crisis averted, Brian?
Well, we were able to separate these into discrete elements. I mean, we came up with individual settlements on each major issue. We decided there's some that were the owner's fault, and really the packaging vendor's fault. And we really had to have a frank conversation about the gaps in the way our client had assigned responsibilities under these various contracts and how this all came together between all these various documents. Then we split the disputed change order in order to get prompt payment on some of the extra work that appeared pretty likely the owner would ultimately have to pay for. The automation vendor waived some of the more questionable items. And some of the problems really were the automation vendor's fault. I mean, in particular, one of its subcontractors had some real performance issues. And at that point, everyone had really kind of come around to the view that that sub did not have its A team on what was really a complicated project. So in order to facilitate this settlement, we helped the parties create an agreed upon corrective work list, and commissioning was put on a strict schedule with very clear pass-fail expectations. The work was performed without additional cost to the owner, but some of it, the problems were with the physical equipment, the specific bad valve that was causing some of the problems, and that was a supplier warranty claim. So the automation vendor wasn't really out of pocket on those issues. And we helped the owner get corresponding commissioning and troubleshooting commitments from that packaging and shipping contractor, so that now the automation vendor was coordinated with the other project participants in getting the commissioning test successfully run.
This is all coming back to me now. Bad memories. Okay, but no lawsuits.
Yeah, that's right. I mean, in this case, the parties were able to avoid the expense of what really would have been a long and complex litigation.
So was the settlement that you're talking about, was that the end of the whole thing?
No, actually, no. The owner did go the extra mile here, and we did a lessons learned debriefing to the management team for the joint venture. And during this webinar today, we can pass that information along to our participants.
Oh, nice setup, Brian. So, what were the lessons learned on? There they are.
There they are. Well, we really had three primary conclusions. I mean, the contracts were insufficient, and look, good fences make good neighbors. A contract customized for an automation project would have eliminated numerous disputes. In particular, clear written functional requirements and performance criteria were in the contract for some of the physical characteristics, but not for the process controls and the automation programming. So there was a lot of arguments between the owner and the integrator about what was acceptable in the industry, because there's nothing in the contract to define it. Another thing we learned is no factory acceptance test performed, and even the planned kind of iterative design confirmation meetings, they were just ignored. So by the time problems were discovered, it was too time consuming and costly to change directions, and the lack of scheduled milestones made it different for those other vendors to kind of play nice to get the project completed on time, on budget, with proper and coordinated performance. If the functional requirements and performance criteria that we just discussed would have been subject to that early create, review, and sign-off process that I mentioned before, everyone would have had a better understanding of their obligations and reasonable expectations. I mean, 30 days before startup is not a good time to have your first real discussion about how these controls and automated systems were actually going to operate in the field.
Got it.
The other thing we learned was that the project delivery method was just flawed. I mean, the owner really did not have the personnel or experience to coordinate and manage those separate vendors. So when one would experience a problem, the owner couldn't help it, couldn't help it affecting the entire project. Right. In real economic terms, if you really want to get down to the nickels and dimes, the additional markup that the owner would have paid to have the automation vendor just include all the equipment would have been easily covered by the savings that the owner would have had, but it's internal personnel that didn't have to do a bunch of things that really were not in their wheelhouse.
Very good. Very good. That's excellent, Brian. So anything else about this one for our automation vendors joining us today?
Well, like an acknowledgement that you aren't responsible for pre-existing conditions of the owner's equipment, like we were just talking about in the first two case studies, Contracts should really make it clear that you also aren't responsible for performance failures, delays, or lack of coordination related to separate vendors that the end user may maintain. I mean, instead, it should actually be the opposite way, and you should be entitled to an equitable extension of the schedule and, where appropriate, payment for your additional costs that arise from problems with people who are not under your control.
Yeah, I totally agree. It's difficult to get that sometimes, but exactly. And having a serious conversation with your customer about what you need from them, including managing any of their vendors and participating with you in the design, should happen before you start the first day of work, hopefully before you even sign the contract.
Yeah, I completely agree.
So I guess that brings us to the final topic of our Lessons from Touching a Hot Stove Legal Edition.
Let's do it.
For this final topic, I am going to take you, Brian, to the very end of an automation project.
Where the part where the integrator gets final payment. I love that part.
Well, yes, but I'm actually thinking about the step that commonly precedes that.
Testing the system.
That's right, the testing of the system. As you know, this goes by a lot of names. It can be called site acceptance testing, or if you prefer the initials SAT, there are other names as well.
Yeah, sure. User acceptance testing, commissioning, like I was just talking about.
Exactly. But whatever you call it, it's the point when the system is in place and the reality of how it works runs headfirst into the customer's expectations.
So do you have a title for this project?
I call this one the case of unending testing.
That sounds a bit ominous.
Like all good hot stove topics. So for this project, I take you to a big city airport, and specifically the baggage handling part of the facility. Our integrator has been hired to automate the conveyors and the sorters and the scanners that move your luggage from the check-in counter to the airplanes and from the airplanes to the baggage claim.
All right.
And as you may know, that process has gotten quite a bit more intense. Since 9/11, there are explosive detection systems, of course, and it is pretty important to accurately keep track of every bag that comes through the airport.
Yeah, so let me ask you a question.
You may.
In the story you're telling, is the federal government involved?
I know where you're going with this. Not directly, but certainly indirectly. And of course, anything the federal government even touches usually can be dependent on to make everything just a little bit more complicated.
Yeah, that's my whole point.
I know. So that's the situation. Our integrator is doing the automation at a baggage handling facility at a brand new terminal at a major airport.
What could possibly go wrong?
Well, maybe everything. Let me give you a list. First, and I could be describing almost any integrator here, but this was a huge issue. This integrator was very big into customer satisfaction. Its attitude was, the customer is always right, which is completely fine until the customer is completely wrong.
Right.
Secondly, the testing criteria for this baggage handling system were not really known ahead of time. When the project had been bid, the customer provided the integrator with a set of criteria from another project and told the integrator, the criteria for testing are going to be something like this.
Something like this.
Something like this. Except they weren't. They turned out to be nothing like this.
Well, when did the integrator finally receive the real criteria then?
Well, it received most of the criteria right before testing.
Most, but not all?
Yep. The criteria were still coming in during testing, and that was just the beginning.
Oh my gosh, it gets worse?
Of course. That's why we're talking about it. It turns out that the speed of the conveyors taking the luggage from one place to another was much faster than the integrator had expected. But because the integrator had a customer is always right mentality, no one protested this. The integrator simply forged ahead, trying to make its system work regardless, but try as they might, the bags kept skidding off the conveyor. And making matters worse, the customer kept adding new tests, including a test that sounds really reasonable when you hear it, but which no one had ever discussed at any time before the project began.
Well, what was this test?
It was called the but-a-bag test. It's a test where you butt two bags against each other to see if the system will count the luggage as one bag or as two. And as it turns out, finding a way to write code that will do that is very difficult, Brian. The system kept counting two bags butted against each other as just one bag.
All right, well, why not just have the humans load the bags with some minimal amount of separation between them as a matter of policy?
Well, that defeats the whole point of automation, does it not? Also, even if you did that, it would not always work. I mean, once in a while, especially given the speed problems of this conveyor, the bags would still slide together no matter what the humans did. Yeah. And even that was not the end of the problems. There also was a problem with the explosive detection machines. They just didn't work very well. Now, they detected explosives just fine. That was okay. But the bags kept getting jammed inside, which, of course, affects everything else upstream in the system.
Yeah. All right. So what did the integrator do then?
No surprise to anybody who knows the way this industry works. Even at this point, the integrator did not protest. It did not object. It kept trying to make its customer happy. And it suffered a tremendous overrun on this project.
No, look, eventually this train has to run off the cliff.
Yes, it does. And yes, it did. Because with so many problems, the testing just never ends. The customer keeps inventing new tests to make sure the problems are addressed. To put it concisely, I mean, our integrator is in testing purgatory.
So we get the call.
We get the call.
And of course, we investigated the situation.
We did. And in meetings with the integrator, we found a lot of what I just described, including this ever-evolving testing criteria and the problems with the speed of the conveyor and the jamming of the explosive detection machines and the difficulty of counting two bags as two bags when they're butted up against each other. But actually, Brian, of all the problems that I just described, the most challenging problems I have not yet told you, and it was created by the integrator itself.
Well, it's got to be its failure to protest anything and acting as if the customer is always right.
Well, yes, but also the things that people employed by the integrator were saying to each other in emails.
Such as?
So they were writing emails that said, our code really sucks. We terribly underbid this project. Basically, really critical stuff about themselves, stuff like that.
Oh, geez, that is not helpful.
Not helpful at all, because now we're in a situation where the customer is withholding money. And we, of course, on behalf of the integrator, are saying all of this unending testing for the past several months is beyond the scope of what was agreed. And right. It's really looking like litigation, Brian, because that's where these things sometimes go. But we know that the litigation, all of those emails are going to come out. So we wisely avoided litigation as a means of preventing those emails from coming out, and instead negotiated something, not perhaps as well as we might have done if we litigated, actually, but it was ultimately resolved through negotiation, although a little bit dicey, which brings us to lessons learned. So here they are. Give attention to testing criteria early. There has to be an end in the panorama and not just the beginning of testing in the contract documents. Do not let a customer is always right mentality run over your company's rights. And toward that end, you should formally request a change order, even if it may make your customer angry. And I don't mention it here, but it's really the big point of all, and that is observe email hygiene. You need to teach your people that whenever they're emailing on a project, and I know there's a lot of emails, but you always have to behave as if it's going to show up in the morning's newspaper. You've got to keep the emails from being self-critical. That's not to mean that they can't be self-critical, but they have to be careful about what they say. So
and that thing with text messages and everything else. I mean, all of the communications are subject to disclosure if there's a dispute. Sure.
That's right. So that concludes our presentation portion from Lessons from a Hot Stove Legal Edition. Let's send it now to our colleague Julie Weller for the close and any questions she may have.
Thank you, Mark. And as a reminder to the CSIA members who are in attendance, the CSIA Legal Plan is a benefit of your membership with the CSIA, and it entitles you to free and reduced fee legal services from the attorneys of Faegre Baker Daniels. For more information about the services and pricing offered under the CSIA Legal Plan, you can send an email to csialegalplan@faegrebd.com or call 1-844-204-0090. So now we will take some questions. If you'd like to ask a question, you can write it in the question box on the webinar, or you can put it in the chat.
Julie, this is Jeannie. We do have a question. This comes from Chris Schleich. Is there any method, service, or tips to vet potential clients for how litigious their organization may be?
Well, I'll take that one. You can do a search to see if a particular company is litigious. Nowadays, unlike the way it was perhaps 20 years ago, there is a lot of information about lawsuits available on the internet, and you can actually accomplish quite a bit by just doing a Google search. It won't tell you the same level of detail about their litigiousness that using a law firm will get you, because we have access to some resources that you would not, but it may advance the ball a little bit. It's not perfect even now because not everything results in a lawsuit. So being litigious also can mean just being cranky and difficult to get along with and uncooperative and demanding, and you don't get that necessarily unless there's been a lawsuit. But it'll at least be a start.
Yeah, I would add, there's also a little bit that you can tell me. It's not, it's more of an art than a science, but sometimes when you're negotiating the contract documents themselves, you might get an indication. So for example, a lot of times we see what people would call a attorney's fees clause that says, in the event of a dispute, how are the fees going to be paid? In the United States, typically parties pay their own way, but you can shift that by contract. A lot of times we see a company will say, like an owner, for example, could say, if I have to sue you, you'll pay all my attorney's fees. And sometimes the easiest way is to say, well, look, let's make it mutual. So in other words, if somebody wins a lawsuit, they pay the other ones. And if they push back against that, that may give you an indication that they use claims as more of a hammer than a shield, or a sword than a shield. And, not perfect, but it may give you, if their attitude towards contract negotiation might be similar to the attitude about claims, the reality is there's disputes and claims on almost any significant project. That's just part of the normal course. There's change orders and delays and things that happen, and how the parties resolve those informally is typically the way that the business will operate if it turns into something significant and they would have to bring a formal claim.
Great. Thank you, Mark and Brian. We have another question from Fred Pickney, and Fred asked, are form contract documents available for system integration work?
I can take the beginning of that. The answer is not really. In various industries, there are more standard form documents. For example, Mark mentioned at the beginning that there's some elements of traditional kind of sticks and bricks construction that overlaps with automation integration projects, especially kind of electrical or low voltage contracts. Those do have some standard forms in the industry. There's the American Institute of Architects, there's consensus docs, there's other trade organizations that put those out. The answer is, in the integration automation industry, there's not really standard forms. There are some documents that you kind of see more regularly, at least in their format. They're not exactly the same, line by line, but some master services agreement, for example, in the pharma industry, a lot of those companies might use the same type of document, though maybe not exactly the same terms. Same thing in aerospace and defense. I mean, there's kind of a way that people do things, but I wouldn't say those are the same as standard forms. We have in the past, and some things created things that we sometimes call like a rider, that we say, look, we're always the square peg in the round hole. So whatever kind of contract form that you want to give us that doesn't really, we're not a pure engineering firm, we're not an electrical subcontractor firm, we're not all of these things that owners may want to kind of try to shove you into, and say, look, this rider, which a relatively short document, can go ahead and kind of amend the real key terms that would help alleviate some of that problem, so you could use other standard forms that don't fit automation in an automation project. But the short answer really is there is not an industry standard document. There's just too much variety within the market verticals in which y'all work.
And I would add that the reason for that, there's a couple of reasons. One is that from the automation contractor's perspective, the integrator, the market power, that the bargaining power that the integrator has is relatively reduced. So you're often operating off of the end user's forms.
Right.
That's an integrator facing answer. From the end user perspective, I think it's because end users have a lack of understanding of many of the necessities of automation projects, the testing aspects, the intellectual property aspects, all of the things that are different about automation and robotics contracts are not seen or fully recognized in the end user community. Therefore, we have a disconnect, which is good for Brian and me, Brian and I, because we fulfill that niche, and we try to backfill the gaps on both ends.
Yeah, I would agree. I spent a lot of time talking to end users and owners about saying, you're trying to put my client, the integrator, in this bucket, and they fit in some of those portions, but not all of them. And so we need to do some work to get this on something that's reasonable to both parties, because we a lot of times try to get pegged into a different role than what we really serve.
All right. Is that the end of the questions?
Looks like those are the only questions we have. Mark and Brian's emails are on this final slide, so if you think of any further questions, feel free to reach out to them. And thank you very much for joining us today for this webinar.
Thank you all.
Thank you.